Let's talk about fair use doctrine. So in the news media world, fair use is where you live. Fair use is what really enables your use of other people's content. Without fair use, without the notion that it's okay to use somebody else's content without their permission, you'd be stuck. You wouldn't be able to write stories about sort of the events of the day, because every time you quoted somebody, you'd be using their words that you didn't create. You can't run a newspaper. You can't have a news show without doing that. So this is what the Fair Use Doctrine says. It's actually a statutory defense to infringement. It says, notwithstanding the exclusive rights in copyright, so long as it's for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, it is not an infringement of copyright if you can fit your use into an analysis that looks at least these factors. These are the so-called 4 factors of fair use. We look at the nature of your use, the second use. We look at the nature of the source, the original work. We look at how much you've taken, and we look at the effect on the value. It used to be said that if your use was commercial, there was no fair use ever. The Supreme Court came along and said, no, there's no bright line rule, there's no yes-no answer. It's a multi-factor test, and it's all about looking at the totality of the circumstances. So let's look at some circumstances. This is a photo and a story that ran in the Denver Post. That's the photo. Yeah. That photo went viral for all kinds of reasons. And when it would, at this time, there was this company called Righthaven, and Righthaven had contracts with the Denver Post and the Las Vegas Review-Journal to engage in copyright enforcement. And Righthaven had a business model where it would sue first and then talk with the people they have sued. And its business model was to get people to pay money because they were afraid of the lawsuit that had already been filed. And Righthaven filed lots of lawsuits. And Righthaven's tactics led to a lot of free speech people being uncomfortable with this notion that you sue first and talk later. And the Righthaven cases ultimately led to some, what I, as a copyright lawyer, think of is unfortunate fair use decisions, where courts reacting to the sort of bullying, perceived bullying in this tactic, found fair use whenever, or not whenever, but in circumstances where the website was using the entire story, or they were using the photo in connection with a story that had nothing to do with the TSA policy of frisking people. It wasn't connected to the photo. It was just using the photo. The Righthaven problem, the problem is, how do copyright owners control their content on the web? When your content is going viral on the web, people are making money off it. They're running ads against it. They're driving traffic because of it. Shouldn't you, as the content creator, get a cut of the value that they are slicing off from your use? And so the Righthaven problem is, how do we deal with what's fair and what's not fair? Where is the fair use line? The first fair use line is, how much have you used? Routinely, I get questions of, how much can we use? Is a headline and the first paragraph too much? If we have a website that scrapes other people's stories and all we're doing is taking the first 2 sentences or the first 70 words or the first something, that's okay, isn't it? The case, Harper and Row case, involved Gerald Ford's memoirs Everybody remember who Gerald Ford was? His book was 200,000 words plus. The Nation magazine got galley proofs of a Time magazine serialization of Gerald Ford's memoir. The Nation ran 300 to 400 words. They were the only 300 words anybody cared about in Gerald Ford's memoir. They were the 300 words that Gerald Ford explained, why? Why did you pardon Richard Nixon? That was the big secret. Everybody thought there was a deal, that Richard Nixon knew that he was going down when Spiro Agnew was almost impeached and stepped down, and Richard Nixon selected this congressman from Michigan. I think it's Grand Rapids. Why? There must have been a deal. There was a quid pro quo. When I go down, you're going to pardon me. Gerald Ford says no. That's what the Nation copied. It was less than 1% of the book. It was very small, but it was the heart of the book. It was the only thing that mattered, or at least that's what the court said. It was the heart of the work, and this case stands for this proposition. Just because you take a little bit, if you take the most important part, or you take a meaningful part, you take a part of the work that is the value of the work, if you take the nut graph, if you take the headline, if you take the part that matters, it's not fair. Or it can be not fair. Just because you take a little bit doesn't mean you're free and clear. I want to play some music. So the first issue is how much have you taken, and then how much have you changed? Have you done the work? Have you done something worth the work that's created something new? Have you contributed to the expression? Have you contributed to the marketplace of ideas? So this is my good friend Roy. And now, let's listen to the boys from Miami. Okay, that got the laugh I was looking for. So this is the Roy Orbison case. It goes all the way up to the Supreme Court. So you know, Two Live Crew actually contacted the Orbison estate and asked for permission to use Pretty Woman. And the Orbison estate said, no effing way are we giving you permission. And the boys from Miami said, okay, we'll do it anyway. And they made the song that you heard, which is very similar to the song that Roy Orbison wrote, owned, conveyed to his heirs, was what Two Live Crew did to Pretty Woman fair? Whether it was art is a different question. The answer is, according to Justice Souter for the Supreme Court in the Campbell case from 1994, yes, it was a fair use. It was a fair use because it transformed the work. Yes, the music was the same, most of the words were the same, but instead of being Roy Orbison's plaintive, crooning, yearning song, good song, Two Live Crew's song is about white men who pick up black prostitutes and who exploit them, a la Roy Orbison. It was a song rewritten with just a little bit of changes of words, to make fun of Roy Orbison. And because of that, or at least that's what the Supreme Court thought, it was fair. It was a criticism. It was a critique. It was a commentary. It's what you guys do. You engage in free speech, in commentary, in a contribution to the marketplace of ideas. Whether Two Live Crew's contribution is valuable, whether it's effective, whether it's worth it, the courts are not going to get into that. But if the use of the other guy's expression is transformed in some way that is a critique or is something new, the fair use doctrine will protect you. More from Campbell. Oh, we've got hands. Yes.
We've got some folks here from the creative advertising side. So if you're pulling, a photo from a client's or business's website and you're creating something new because it's an ad, is that?
Okay, so the question is, on the ad side, you take a photo from the person or the business about whom the ad is built. Or not. Well, if the photo is being used for the same purpose that the photo was originally taken, the photo is being used to promote the business, it's not transformative. You haven't transformed the use. If you, however, take the photo in order to critique the photo, or to critique the person in the photo, or to make a comment on the photo or on the thing in the photo, now you're transforming the use. Now you're doing something different. But if the purpose of the original photo was promotional, and you're promoting, you're engaging in a promotional use, you have not transformed. You have not done something new. Similarly, like with the TSA photo, if the purpose of the photo was informational, the purpose of the photo was to convey what the TSA is doing. If the purpose of your reuse of the photo is to convey what the TSA is doing, you have not transformed that photo. If the purpose of your use is to engage in a commentary about TSA's practices, then you've transformed it. If the purpose of your commentary use of the photo is to critique the photographer's use of the f/22 stop in the lens, okay, yes, maybe. But you get the idea. You need to do it for a different purpose.
Doesn't the Roy Orbison case fall under where they're making money off of that use, though, commercial?
Right. So the question is, doesn't the Roy Orbison case depend upon the commercial use? And what the Supreme Court said, because that was how the case was decided originally in the lower courts, that Two Live Crew's use was not fair because Two Live Crew was making money. They were selling records. And the Supreme Court said, no. That's not the test, and it's not a bright line, yes, no. Yes, they are engaging in a commercial use, but that's just one of the many factors. And at the end of the day, what we care about more, Supreme Court says, is not so much whether you're making money off of it, because everybody, hopefully, is making money off of their content. We really would like to make money off of the content that we create. The fact that you make money off of your content is not decisive. What is decisive for fair use purposes is whether you've done something new, whether you've contributed some new form of expression.
So on the creative side, if we're going to publish in an ad a photo that we got from a realtor, it would probably be in our best interest, or if we did a car ad and we got it from the car dealership or anything,
Right. So
it would be in our best interest to have like some blanket
permission.
letter
Yes.
that we already have an agreement, so we have an umbrella.
Yes. Or
from that advertiser.
Right. The advertiser, I mean, the best thing, what the lawyer in me will tell you is, the best thing to do is get the advertiser to sign an agreement that says, if you, Freedom, get sued, I'll pay.
Right.
I'll indemnify you. And then the other thing I want is to make sure the advertiser has insurance so that when I get sued, he really will pay me. But that's usually not possible. But the best thing is to have a written agreement that gets some form of permission or consent. Yes?
Okay, so like you were talking about math, like maps and stuff?
Maps from like Google or from,
Well, we don't know, they come from the,
yeah,
whoever, the advertiser or whatever, but you can tell they're probably Google Maps.
right, right. The answer is Google doesn't engage in this kind of litigation, so you're probably safe. And I would expect most MapQuest, I don't know if MapQuest will, but the short answer is it's always best to get permission. But if you don't get permission, then it's just a risk assessment. How likely is it that I'm going to get sued for this? And sometimes you decide, I don't know if I'm likely to get sued, but I also know that if I get sued, I can take it, or if I get notice, I'll take it down before they sue me. I'll limit my damage. That's probably before that moment, before you actually push the button, you want to talk. You want to raise your hand and you want to say, somebody else, let's bounce this idea back and forth. Because I think we're not likely to get sued, but what do you think? Do you think we're likely to get sued? And at some point, I want you to be talking to a lawyer who actually deals with lawsuits, who can tell you whether or not it's likely to get sued. Yes?
Does putting up a, does going along with a cease and desist right away limit their ability to actually litigate it?
Does taking down content upon receipt of a takedown of a cease and desist letter limit your liability? The answer is it helps, but it doesn't eliminate your liability. In fact, it's something we will tell you to do. As lawyers, we will tell you to take it down as soon as we get notice, just because it's the safest thing to do, but it doesn't mean that we are going to avoid a lawsuit. Yes?
Is news reporting transformative use? In other words, it's not a commentary, it's a straightforward news account trying to tell what happened.
Right. So is news reporting a transformative use? The answer is it's better. We're getting further down the road. But if you are taking somebody else's photo, say it's a photo of a gentleman being stoned in the streets of East LA during the riots, Rodney King, you take that photo and you use it to illustrate your story about the riots in Los Angeles. The answer is, at the moment that the riots are going on and for the next few days, it's fair. But after the passage of time, when now we're talking about the archival use of a photo, and so you're going to do a retrospective story, a year later, a decade later, after the riots, we're going to look back and we're going to use this photo. That's the moment where it may not be fair, even though it's transformative. Because there is some sense that there's a difference in the fairness when the moment is happening versus several years later. Yes?
We have a photo archive, and there's our photos, but also there's AP photos in there, there's Bloomberg, things like that. Can we assume that it's okay to use a photo from our own archive, that we have gotten the proper permission for that?
So the question is, you have photo archives, you have content in the archives from various sources. Is it safe to assume that you have the right to use the content because the content is in your archive? The answer is, if the content was originally from the newspaper, it is safe. If the content is from a third party and it's in your archive, it is not safe. It is highly likely that if you got the content from some third party, the permission for the use of the content was limited in time. The permission, so you get these publicity headshots of the business executive for the company, and the business gives you that headshot, it goes into your archives and it sits there. And 10 years later, the executive gets arrested for murdering his wife. Do you have permission to use the photo in that context? No, you don't have permission. The photo was given to you to illustrate the fact that he's the CEO of XYZ company. Do you have a fair use? Is it fair to use the photo even if you don't have permission? Yes. If you're using the photo to illustrate the news story about the fact that this guy has been arrested, you're no longer using it. It's very transformative at this point. You're no longer using it for the same purpose. It's very breaking news. It's fair. I will tell you, it's fair. Could you resell the photo? Could you put the photo up on your site for people to buy reprints? No. Don't sell photos that you don't own the rights to. You may have the ability to use the fair use doctrine to protect your own use, but if you start selling the photo, that's different.
On that note, sometimes we'll sell a full page, as a reprint to various places, and people are they're after one of the elements on that page, but there are other elements on that page that we might not own, like a photo.
Yeah.
Are we in any other problems with that?
So the question is, you sell a page, parts of the page you create, parts of the page come from other sources. Who's the publisher? Are we the publisher? We print the thing, it's coming off of our press. We're stuck. We may be able to turn around and point to the guy who gave us the content, and this is where I want the indemnification language. I want the agreement that says if I get sued for what you gave me in this full-page ad, you're going to pay for what because I'm just passing the content through. That's where I want an indemnification agreement. But the short answer is we're liable for everything that we do. Yes?
Does breaking news, the term, now cover, non-traditional cops, courts, hard news? Because we have a lot of new beats.
Yeah.
And there are things going on them that, in a traditional sense, you would not consider breaking news, but because we're like blogging our brains out every day, we consider it breaking news every 5 minutes.
Right. So does the fact of a 24-hour news cycle mean that what was not breaking before is breaking now? Breaking news just means it's timely. It's emergent. It's not something that takes a while to develop. And the answer is, if the facts are that this is a breaking story in that sense, it's timely. It's happening in the moment, or at least within a short time. It's breaking, even if it's because it's well, I don't know about this. Suppose you've got a food page and you're putting a photo on your food page that illustrates the recipe, and you're updating your food page every 4 hours. God knows why. I'm not so sure that that's breaking, because I don't have a sense that it's necessary to update your page every 4 hours. But I will make that argument for you that this is breaking news, so we should be entitled to the fair use protection. I want to move and give you a scenario that we can actually sink our teeth in.